We cannot hear you, Your Honor. You're muted.
Can't say curse words on Zoom, can you? Okay, everybody hear me?
Yes, sir.
Yes, Your Honor.
Okay, welcome back to Bexar County Court at Law number 6 in the Bexar County Veterans Treatment Court Zoom. Today is Monday, August 22nd, 2022 at approximately 2:10 p.m. We have a hearing scheduled, styled cause number 671157, State of Texas versus Abraham Ogween, filed by Ms. Sophie Martinez. And this is a motion to dismiss for lack of due diligence and violation of right to speedy trial. And representing the state, Mr. John San Heinrich.
Thank you, Judge.
And that's all we need. That being said, Ms. Martinez, would you please briefly state what the basis of your motion is?
Yes, Judge. I had filed a motion for speedy trial and then a motion for dismissal for lack of due diligence and speedy trial violations. As we get started, Judge, I believe there was a copy of a certified copy of the clerk's original information and the complaint and the transfer order that was certified and I believe provided. I left an original copy with the court. And if the court reporter would mark that as defense exhibit number 1, I would like to present that to the court and share the screen there.
And so if I apologize for interrupting, I missed the first step. Let me reference the document entitled Defendant's Consent to Hearing by Video Conference in Clause 670157. State of Texas versus Abraham Ogween, which is purportedly signed both by Mr. Ogween and by his attorney, Sophie Martinez. Mr. Ogween, is this your signature on this document, sir?
Yes, sir.
And Ms. Martinez, as attorney for Mr. Ogween, is this your signature on this document?
Yes, Judge.
And for purposes of the record, the court takes judicial notice of what appear to be certified copies of documents that are filed in the court's official file. One is the actual information on this particular case. And it looks like it was filed December 21st, 2021. Does that sound right, so?
That's correct, Judge. That's the file
And the
standard.
next document I have is a complaint. And apparently that was filed the same day. I can't really see the date clearly on this particular copy, but it is a certified copy. And that's what I have. Yeah, are there other certified copies I'm supposed to take notice of, so?
Judge, it was the order, the complaint that's also dated December 21st, and then the order transferring the case that's a certified copy to County Court number 6 from County Court 2 on June the 13th, Judge. Those were the certified copies I was asking the court to take judicial notice of. And Judge, in addition to that, I would like the court to take judicial notice of the court file. If the court has the copy of the court jacket, does the court have that? All right, Judge, I'd like the court to take judicial notice of the name of the defendant, Abraham Ogween, the offense date of October the 6th of 2021 for a DWI in County Court 2, cause number 671157. SID number 1153969, and the court to take judicial notice of that. And in addition to that, the D page that was provided that showed the booking date, arrest date of 10/6, booking date of 10/6, the bond made in that case of 10/6 also, and also the initial arraignment that was to be set for 11/5 and the complaint received in the court of 12/21 and the transfer on June 14th. So I'd ask the court to take judicial notice of those documents.
That is all accurate, and I do take judicial notice of all those documents. Also, for purposes of the record, let's say Defense Exhibit 1 for identification is the certified copy of the information. Defense Exhibit 2 for identification is a certified copy of the complaint. And Defense Exhibit 3 for identification is a certified copy of the order transferring the cause. And for purposes of this hearing only, I assume you would like me to admit those into evidence. Is that correct, Ms. Martinez?
Yes, Your Honor.
Any objection from the state?
No objection, Your Honor.
They shall be admitted. Go ahead, so.
All right, Judge. Judge, and in our motion here today, basically, Having established those dates, Judge, we will be calling Mr. Abraham Olguin as a witness in this case. We've established on the record, but he will testify, the offense date of October 6th, and today being October the 6th of 2021, and today being August the 22nd of 2022. We are advising the court that that's been 10.5 months since the date of the arrest to today's hearing, so that we're, and he will testify to those dates, meeting the threshold to trigger the Barker v. Wingo balancing test. So if we could ask Mr. Olguin, bring him
Hang on
into.
just a minute. So let me see if the state will just stipulate. State, do you stipulate that the offense date in this case, which is called 671-157 Theta, Texas versus Abraham Olguin, is as stated by Ms. Martinez, 10/6/21?
State does stipulate to that, Judge.
And would you also stipulate that it's been approximately 10.5 months since the offense date, 10/6/21, to today's present date, which is August 22nd, 22?
Yes, Your Honor, we do stipulate.
Okay, and I think it's established by case law primarily that presumptively 8 months delay would trigger a defense ability to file a motion to dismiss for lack of speedy trial. Do you agree with that, Ms. Martinez?
Yes, Your Honor.
And
Texas
they
law.
do agree with that. That's the standard federal law basis for this particular type of motion.
I do, Your Honor.
And
do agree.
the Barker v. Wingo requirements, the first prong is the length of delay. So we've got that. Anybody have anything else further we need to talk about the length of delay? We all agree that it's approximately 10.5 months since the date of the offense.
Yes, Your Honor.
Okay. Reason for delay. Go ahead, Soph. Obviously we have COVID in there somewhere, and we have County Court 2 inefficiency in there somewhere, and then whatever else you would like to talk about.
Yes, Judge. I would like to call Mr. Abraham Olguin, Your Honor, as a witness.
Mr. Olguin, please raise your right hand, sir. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Defense, your witness.
Thank you, Your Honor. And Mr. Olguin, just for the record, would you please restate your name?
Yes, my name is Abraham Olguin. Yes, ma'am.
Okay. And it's been established already that you were arrested and booked for the offense of DWI on 10/6/21. Is that correct?
Yes, ma'am.
Okay. Now, Mr. Olguin, when you were released from jail, were you given a court date?
Yes, I was.
Do you remember what that court date was?
Yes, it was 11/5/2021.
Okay. And did you ever, was that court date ever held?
No, I was not.
Okay. And do you know why that court date was never held?
With talks to my attorney, I knew that there was lack of there was something going on with the court, and there was not a lot of court cases getting placed. So it wasn't filed yet. My court wasn't filed yet. My case wasn't filed yet.
Do you know when they created a file for your case?
Yes, it was 12/22/2021.
December 21st of 21? Was that the date you
Well,
remember?
Yes, yes.
So anytime in between your initial court date of November the 5th, how were you notified that you were not going to have a court date on that date?
I was notified through talks to my attorney. She notified me through, she was always in contact with me.
Which was me, right? I mean, your attorney was me.
Yes, ma'am.
Okay, all right.
I was in contact with her multiple times through emails, through calls, knowing that I know she reached out to the DA as much as she could, but I know that there was still not anything going on. Yeah.
Okay, so anytime while your case was pending in County Court 2, were you ever given a court date in that court?
No.
All right, and do you know were you aware of whether the court was scheduling any court dates in your discussions with me as your attorney?
They were scheduling court dates, but they were scheduling the older court dates first before mine.
Okay, and other than the state, other than the court not scheduling you a court date, did we ever have discussions on my conversations with the DA's office for your case?
Yes, there was multiple conversations and emails that you sent me, as well as conversations over the phone that we had, saying that you did reach out multiple times and got no responses back.
Okay, and did you know how I had reached out to the district attorney's office?
Yes,
How did I reach out to them?
through email.
Okay, and were you privy to, did you get to see those emails?
Yes, I did got to view them. Yes, ma'am.
Okay, and you reviewed and read all the emails?
Yes, ma'am.
Okay, and were you aware of whether there was any response from any of the emails that I continue to send the district attorney's office?
There was one response saying that there was a transfer, that there was a new transfer, that we got a new person that you were in contact with. And after we got set up with somebody new, you tried to email them and try to contact them, and they did not get a response back. So the only response that we did get back was the one saying that we're transferring to somebody new.
Okay, and so do you, I did provide you copies of those emails, is that correct?
Yes, ma'am.
And so were you aware or do you have access to those emails?
Yes, I do.
Okay, so do you, were you aware when the first email was that I had tried to contact the district attorney's office?
Yes.
Can you tell me the date of that email?
The date of that email was,
You have it available, you can look at it, but you know.
I think it was 12, sorry, it was 11:15, I think. November
Okay.
15th.
No, on the emails that I provided you copies of, when I reached out to the Mr. Rafael Martinez Horta, did you see the email that I provided you dated December 13th of 21? Did you get to see?
Yes,
those?
yes, I do. I did see that one. Yes, I have that one here.
Okay, and did you know whether or not I ever got a response to that email?
No, we did not.
Okay, did you see the email that I followed up with on December 15th of 21? Did you get to see that email?
Yes, ma'am, I did.
And do you know whether we ever received a response to that email?
No, ma'am.
All right, and then did you get to read the email that I sent on December 27th of 2021?
Yes,
And did you, in response to your testimony earlier, you said that that was the one email you believe the DA had responded to saying he was leaving?
yes, he was leaving and I was appointed a new one.
Okay, and then did you get to review the email that I sent to the DA's office on January 4th of 2022?
Yes,
All right, and do you know
I
whether
reviewed
there
it.
was ever a response to that?
Did not get a response back.
All right, and did you get to read the email that I sent to the DA's office on June 1st of 2022?
Yes, ma'am.
And was there a response to that?
There was not.
And on June 8th of 2022?
Yeah, I did see the email. There was no response back either.
So to the best of your knowledge, did the DA's office ever respond to any of our requests for review or offers in your case?
No, there was no response back.
Okay, did the DA's office ever assist us in trying to move this case forward by offering any kind of information or responding to any of my calls, in-person visits, phone calls, or emails?
No, there was no response.
So it's your testimony that after several attempts, you were aware that I had attempted to communicate with the coordinator of the court to try to get court dates and get court settings. Is that correct?
Yes, there was multiple communications. Yes.
And are you aware of, do you remember why it is that we were unable to get any kind of settings?
Sorry, repeat the question.
Were you aware why we were unable to get any kind of setting in that court?
Yes, ma'am.
Okay, and do you remember what that reason was?
There was to not get a court date, you said? Yes. To not get a court date because we got appointed a new court and then they were still working on older ones. And we didn't get ours yet.
Were you aware of any kind of backlog that was occurring in
Yes, I
county
did.
courts?
I did see that there was backlogs going on, as well as I did see on the news as well that there was definitely something going on in that in county court too, with the backlogs. Yes.
Okay, so was this, was our reason for being delayed and getting any kind of court date or hearings at any time in relation to anything that you had done?
No,
Did you refuse to attend court at any point?
no, ma'am.
Did you sign any kind of reset saying that we were going to not appear or that you were agreeing to any kind of court resets?
No, ma'am. Did not
Were
sign
you
it.
ever provided an opportunity to ever appear in that court?
No.
Okay. In moving forward in this case, did you become aware of some point that your case was going to be moved to another court?
Yes, I was aware that it was going to be moved to County Court 6, yes.
Okay, and how did you become aware of that?
I was aware through an email he told me, as well as something that you sent me, as well an email I got in my inboxes as well.
Okay, so throughout this time, was there any time that you believe in your discussions with me as your attorney or in the information you were provided from communication with the court or emails that you were ever waiving your right to move forward to try to assert a right to have your case heard in court?
No, I was not.
Okay. Were you aware that when that we had asserted or that we made attempts to get court dates and to communicate with the DA's office, but we had no responses for either one?
Yes, I was aware.
Okay. Throughout this time, while we were waiting for all of this to occur, did you suffer any kind of prejudice or loss in relation to anything related to this case? Did you suffer any kind of impairment in your in our ability to prepare a trial for you?
Yes, I definitely I had I lost anxiety. It was anxiety and concern, as well as a financial loss, financial future, and future opportunities as well as a certain witness.
But did you at any time throughout this process, was your defense impaired by the loss of any kind of witnesses in your case?
Yes.
Okay, and what who was that person that would have been a witness? Do you remember the name of that individual?
Yes, his name was Gio.
Okay, and have you been able to communicate with Gio at all?
Due to not being able to have a court case, I had to leave San Antonio, so I haven't been able to contact him. No, I have not recently.
You reached out, have you tried to reach out to him through contacts and people that you knew so that you could reach him and get a hold of him?
Yes, I have. The last thing they told me that he was leaving San Antonio, but they haven't heard from him since.
Okay, did you make efforts to locate him through other people and any kinds of other any kind of methods that you could to locate him?
Yes, I talked to friends that knew him or that knew me as well, and that's when they gave me that information. And I was not able to contact him, but I was reaching out, trying to.
Okay, and so you don't have a number or an address or any way that we can locate him at this time?
No, ma'am, I do not.
All right, and was Gio considered somebody that was a material or relevant witness to facts in your case?
Yes, he was somebody that had facts. The only he could have evidence through him that he could testify.
So in other words, if you didn't have him as a witness, that evidence was not going to be able to come into court?
Yes.
Okay, and so you believe, or did you believe that those facts were relevant to important for a jury to know and relevant to your defense?
Yes, it was important for the jury to know.
Okay, now other than this, which is a very big loss, the use of the loss of a material witness, was there other losses that you incurred or other anxiety and concern that you suffered because of this delay?
Yes, at the time I had a financial loss, as well as a financial future, as well as future opportunities that I did lose through all this.
Okay, well, let's step back and can you tell the court, where were you enrolled in school at the time that you got arrested?
Yes, I was enrolled at the University of Texas, San Antonio. I was on scholarship playing football.
Okay,
For the university.
So you were, what was your position?
I was a lineman.
So when you were playing football for UTSA, were you on scholarship?
Yes,
All right. Was this a full scholarship covering tuition, room and board tuition?
yes, ma'am.
Okay. Was there any additional benefits you were receiving other than room and board?
Yes, I had a sponsor that was helping me with my training as well as outside necessities.
Okay. So when you got arrested, did that affect your ability to play?
Yes, it did. Due to no case resolution, I was hurted by having to leave the team in the spring.
Okay, so did you have discussions with me about your need to have this case resolved before the end of your spring semester?
Yes, ma'am.
And what was your concern about, had you discussed loss of your scholarships or your financial tuition and everything with your coaches?
Yes, I did talk with them, yes. And they told me
And-
that due to no resolution, if I wasn't going to get a resolution, that I was going to have to lose what I was given.
So when your case was not resolved at the end of the spring semester, were you released from your scholarship and you had to leave the university?
Yes, ma'am.
So can you give me an estimate or tell the court how much tuition and room and board you were and scholarship information you were receiving per semester?
I would say through scholarship and as well as my sponsor, probably about 7,000, around 7,000 a year.
Semester, you had said.
Yes, per semester, yes.
Okay, so you lost that and you were not going to have payment for that scholarship money anymore. Is that correct?
No, ma'am, it was not.
Now, other than that, was there any other, were you in negotiations for any kind of contract or professional opportunity for the summer?
Yes, ma'am. So during the summer, I got offered a contract in a pro football league in Atlanta. I was going to get a signing bonus as well, close to about 10,000 for that. But due to lack of not being able to get a court date or case resolution, I was able to have to let that go until there was a decision made.
So you were offered a contract, you're telling the court, but that contract was withdrawn because this case was still pending?
Yes, it was voided. Yes.
Okay. And so you believe you lost about how much money due to that?
With the signing bonus around 15,000.
And so that opportunity was gone. Were there other opportunities that not being on a collegiate roster and not being on a team, were there other opportunities that you lost because of that?
Yes, I lost the opportunity to play college ball. That's the biggest thing for pros to look at me. Whenever you play college ball, they have to look at you. And then as well, I lost a chance to be at the pro level as well to gain financial earns as well.
Right. And ultimately, this semester, where are you this semester?
Right now, I transferred to the University of North Texas.
Okay. And the fact that your case is pending, has that still caused you more loss and financial loss and anxiety and concern?
Yes, it caused me a lot of anxiety and concern due to the fact that I can't walk on until this is resolved.
All right. So is the school not, was the school not allowing you to be considered for the team because you had a case pending?
Yes, ma'am.
Were you not allowed to try to get any kind of scholarship money for the way you were playing before because you still had the case pending?
Yes, ma'am.
So at this point in time, how are you paying for school?
Out of pocket and
Okay.
working.
All right, so all the scholarship money, the tuitions, the sponsors, the money that you were to receive this summer and your ability to play pro, those are all opportunities that have been lost due to this case still pending?
Yes, ma'am.
Okay. And do you know whether or not was it your understanding from your coach that as this case had been resolved, that you would have been able to continue your to play on the UTSA football team and not lose your contracts?
Yes, it was communicated that if it was get resolved, I would be able to stay as well as a contract. So yes, it was communicated. Yes, ma'am.
Now, was there anything that you had done or that you understand that you did to cause any of these losses to yourself?
No. I believe that due to not having this being put on as quick, it definitely took away a lot of my time. Right now, I've already lost a lot, so it's definitely something that I'm hurting from.
So presently, do you have any way to recuperate any of the scholarship money you've already lost, or the summer contract that you lost, or any of your pro viewing opportunities that have already passed you by?
No, they are not. I cannot recuperate those. Those are something that I suffered.
Okay.
Yes, ma'am.
Any further questions, Ms. Martinez?
I don't think so. Not at this time.
I'm sorry, your audio is fading on me for some reason.
I'm sorry, Judge. I think no further questions at this time.
State cross-examination?
Yes, please, Your Honor. Is it Mr. Alguin? How do I pronounce your last name, sir?
Ogin.
Ogin?
Yes.
Ogin? Okay, I'm sorry. If I ask any questions you don't understand, ask me and I'll repeat them for you, okay? And if I'm going too fast, just slow me down. Sometimes I get excited, okay, sir?
Yes, sir.
Okay, so you were arrested on October 6th of 2021, isn't that correct?
Yes, sir.
And you stated that you were aware, on your own and through your counsel that something was going on with the courts during that time, isn't that correct?
Yes, sir.
One of those things being the COVID pandemic, isn't that correct?
Yes, sir.
And you're aware that during the COVID pandemic, Supreme Court orders came down, basically, which inhibited the state's ability to conduct a jury trial during those times?
Yes, I wasn't appointed a court. I wasn't given it till 12/21, 2022, 2021. I know that.
When you say given it, what do you mean? What were you given?
I wasn't given I wasn't filed yet. I know that.
Okay. Okay. And that was in December of 2021. That's what you said, sir?
Yes, sir. I know I was given a court date on 11/5, but it wasn't filed till 12/21.
Okay. You stated that through your attorney, you were CC'd or you were receiving emails of her attempting to reach out to the district attorney's office. Is
Yes,
that
sir.
correct?
Yes, sir.
And you received a series of them. In fact, starting about November 15th of 2021 and going through about September or June of this year. Is that correct?
Yes, sir.
And the whole time you're not getting any response?
No, I was not.
And I'm sure you and your counsel are aware that it's not a statutory requirement for the state to proffer an offer in your case.
Yes.
And you're being aware of that, and I know your counsel is aware of that, at any time between 11/15/2021 and the filing of this motion, did you file a request on your case to be set for trial?
No, not in county court 6, no.
So you never, I just want to be clear, sir, so you never requested a trial setting in your case?
No.
Not to your knowledge. Okay, sir. Before the case was transferred to County Court 6, had you been to any court hearings in County Court 2?
No, I had not.
Not a one?
Not one. Not
Not
any.
one. Okay. Okay, so you're saying that this delay has you've basically lost the opportunity to present your case, and you're giving the reason for that by the loss of this Geo. Who is Geo? Can you give a full name of this individual? And
I just call him by Gio. I don't know his last name. I think his last name was Garcia, I think, if I remember.
so how is he a witness in this case if you don't really know him too well, sir?
He knew prior, before I got arrested, what was going on.
So he knew before, but he wasn't there on the date that you were arrested?
No, I was not there. I'm saying that I was there before. He was just there.
I'm sorry, explain this again. So Gio was not there the day you were
He
arrested?
was there.
He was there.
Yes, sir.
Okay.
It's not when I got arrested. I'm saying I've seen him before, talked to him before.
So he wasn't there when the police showed up?
No, sir.
Okay. Who is this Gio to you again? Just some guy you know?
Yes, sir.
How do you know him?
Friend.
He's a friend, but you don't know his last name.
Mm.
Okay. How many times have you attempted to reach out to Gio from the filing of this case? How many?
Few times, probably several times.
Is it a few or is it several?
Several.
And how many is in several?
Several times.
You can't give an estimate, just several? Okay. Have you tried to reach out to him through any social media, Facebook, anything like that?
I tried to find him on certain media platforms, but I could not.
Did you provide this name to your attorney?
Yes.
Did the two of you attempt to hire a private investigator and find this individual?
No.
Have you provided that name to the district attorney's office to have our investigators attempt to find this individual?
No.
How is he a material witness in your case, sir? What would you anticipate him to be able to share with the court?
He was able to provide information that would be helpful for the jury.
For the jury of your innocence, sir?
Yes, sir.
Okay. And just general information? We don't have to, I know we don't have to get into specifics if you don't want to, but is it general?
Just information.
Just information. So we could provide information that would be helpful to the jury, but you didn't provide funds or ask the district attorney's office to go ahead and try to locate him through the use of a private investigator. Is that correct?
I don't know all the technicalities, but I just know that anything that was there through him, it would have been evidence through him.
But you didn't try to use anybody or any services to try to locate this very critical individual?
No, not at the moment.
Okay. Okay, so you were talking about playing football.
Yes, sir.
And again, okay, so the offense date was in October of 2021. And sir, you testified that you were forced to leave the team in the spring of 2022. Is that correct?
Yes, sir.
And then no times during that time, and you knew the rules of the team, right? When it comes to if it's a non-resolved issue that you have to leave the team?
Yes, that was what talks to my coach.
Okay, and that was, okay, so from October to springtime, pretty quick. It's about what, 5 months? I don't know. When does spring start? March. So yeah, 5 months.
Yes, sir.
Were you still able to find Gio during this time?
Say again?
Between October 6th of 2021 and say March 21st of 2022, were you still able to find Gio at that time?
All I know is that that I know that he would provide evidence to the jury to help me and everything on that time. And
I know, sir. I know, sir, but if you could focus on the question I'm asking, sir, between beginning of October when you were arrested for this offense until March 21st, which is the first day of spring, or whenever the coach at UTSA had to release you, were you still in contact with Gio at that time?
No, I was not.
Okay. So you wouldn't have, if we'd have set this case for trial, then March 22nd of 2022, you still wouldn't have been able to find Gio based on what you're telling me. Isn't that true?
Yes, sir.
When did you lose contact with him?
A little bit after. He just a little bit after that. Yes, sir.
A little bit after what?
A little
Give
bit
me a
after what happened. A little bit after I got arrested. Yes, sir.
Okay. Okay. I'm sorry. Thank you, counsel. All right, so you're also discussing with the court that you were provided with a opportunity to go play pro football out of Atlanta. Is that with the Falcons?
It was just a pro team. I can't really say much, but it was a pro team.
You can't say much, so how close was this contract? Did you bring any proof or anything to give to the court? Did you get a letter?
I definitely provided information to my attorney, and she has a.
You did? Okay. Do you have an agent? Or are you doing this on your own?
No, I do not have an agent.
Okay.
I'm in talks with agents, but I do not have an agent.
All right, we'll talk to you after we get done with this. Talk to your lawyer, so she'll help you out with that, okay?
Yeah, sure. Thank you.
So you also testified that you needed to be playing college football in order that would help your chances playing pro football.
Yes,
So
sir.
you weren't, that's correct. So you weren't playing college football since last spring. So when did this opportunity come up in Atlanta?
It was reached out to me through a private message and a tryout.
A tryout? And this was after you were let go with the team for UTSA?
Yes, sir.
But you did testify that you need college in order to get exposure to the pros. So
It was a summer league.
summer league. Okay, I'm sorry, man. I'm not understanding.
No, that's
Um,
understandable.
Give me one quick second, please, Judge.
Sure.
Sorry, sir. I had to look at some paperwork here. Got a lot of stuff in front of me.
Okay.
I believe I've asked this question and defense counsel, correct me if I'm wrong. To your knowledge, sir, did you or your attorney ever set this case for trial?
I know that there is a trial hearing. I know that, but I don't, yeah.
Yeah, there's a trial hearing here in November, I believe. Do you know when that trial was set? When the November trial setting was given to you, sir?
No, I do not.
Would it surprise you if that trial setting was given to you relatively quickly after County Court at Law number 6 received your file on the 1st of July, 2022? Would that surprise you?
Say again, sorry, repeating.
Would it surprise you if your case was set for trial within a 30 to 45 day time frame of County Court at Law number 6 receiving your file?
It wouldn't surprise me.
Wouldn't surprise you. To your knowledge, sir, did you or your attorney set this case for any pretrial conference after receiving numerous non-responsive emails asking for a state's offer on your case? Did you, after not receiving any offers or any responses from the district attorney's office, did you set it for a pretrial conference to figure out what's going on?
I'm just notified that I wasn't able to get a court date, and I was not set for any pretrial or anything like that due to like no communication.
Okay. But you or your lawyer didn't reach out to the court and try to set it for a pretrial?
I know we'll talk to my attorney. She did what she could to,
Okay.
to see up the process, whatever she did.
I understand, sir. I understand. Sir, when the case was still set in County Court at Law number 2, did you ever appear via Zoom in court as it was their practice?
I never got on Zoom. No.
Not once.
No.
Okay, sir. Your Honor, one moment.
Sure.
Your Honor, I believe the state's got no further questions for this witness at this time.
Ms. Martinez, anything further to redirect?
Mr. Holguin, after the time that you got arrested and throughout the time that your case was in County Court number 2, did you have constant communication with me as to the status of your case?
Yes.
Were you notified as to the procedures of County Court 2 and why you were not given a court date?
Yes, I was notified.
And do you remember what the procedures or how the court conducted their court hearings in County Court 2?
Yes.
Do you remember what it was that you were instructed as to why you didn't have a Zoom date or a court date or any kind of date in County Court 2?
Yes, I was notified how that worked.
And what do you remember being the reason that you were not given a court date?
Due to there was no set for pretrial.
Okay, but did you understand that in that court date, you couldn't have a setting date for a trial or a plea without having a pretrial conference date?
Yes, ma'am. I knew that.
And did I indicate to you that we attempted on many occasions to talk to the coordinator to get pretrial conference court dates?
Could you repeat that? I think you cut out right there again. Sorry, excuse me.
Said, did you remember that I indicated to you on at least 8 to 10 occasions that we attempted to communicate with the coordinator, Mr. Opara, to get a pretrial court date, but we were not provided one?
Yes. You sent me
And do you,
emails.
and do you remember why we were not provided one?
Because they were still working on other ones, older cases.
Oh, so was it your understanding that there was a backlog in the court and they were taking all the older cases first?
Yes, I did. That was to my understanding. Yes, when you reached out to me and communicated with me. Yes.
Okay, so it was your understanding that we tried to get a pretrial conference court date, but the court would not provide us one.
Yes.
And through your communication with me, you also learned that the first time we were given a court date, even though we had requested on many occasions through emails, through phone conversations and in person, was when our case was finally transferred to County Court 6.
Yes.
Okay. And in reference to communication with Gio, you were able to have communication with him while you were at the University of Texas, San Antonio, because he was here in San Antonio, is that correct?
Yes, it was.
The people that you knew or that knew him that were in communication with you also had communication with him while he was here, right?
Yes, like I said, I tried to reach out to him after due to so many months, but I couldn't get a hold of him. But yes, it was in communication when I was there, ETSA.
So you didn't have any reason to believe up through the time that you were at school that you wouldn't be able to communicate with him while you were in San Antonio?
Yes, while I was in San Antonio, yes.
Okay. No further questions, Your Honor.
Dade, anything further?
Yes, sir. Yes, Your Honor. Just a couple of questions, maybe just one. Mr. Ogun, can you help me out again with that last name?
Ogin.
Ogin, I'm sorry. Hey, my last
Okay.
name's Stan Heinrich, and I get upset when people say that one wrong too. So I hear you. But were you and your attorney aware that it was County Court at Law number 2's practice for defense counsel to set pretrial conferences?
Yes.
And are you also aware that generally is practiced over there in that court, you have 6 months from the date of arrest to go ahead and set your case for a pretrial conference?
Yes.
And you knowing all this, you still did not set the case for pretrial conferences, isn't that correct?
I did not get a pretrial conference.
But you didn't reach out to the court to set one, isn't that correct?
I knew how the court worked, and when my attorney did, I knew she was going to file whatever she needed to do to get to where I needed to get.
Okay, I'm going to ask the question one more time. Sir, did you, during that time frame, call County Court at Law number 2 and set your case for a pretrial conference?
I know my attorney communicated with the courts and what she needed to communicate with, and she communicated with me. My understanding is I needed a pretrial and I did not get one.
But you didn't set one?
I did not get one.
Okay. Your Honor, no further questions at this time.
Anything further, Ms. Martinez?
No, Your Honor.
Mr. Ogin, got a couple questions for you.
Yes, sir.
you were arrested apparently on or about October 6th, 2021. When did this witness disappear? When did you stop being able to contact this witness?
Due to I stopped contacting him a little bit after that. And then when I was trying to reach out to him more and more throughout the year, he kind of started fading away.
So when is the last time, and I apologize, was this guy's name Vito, V as in Victor, ITO, or what is it?
Geo.
Vito with a Z, like Zulu?
Like as
Like
Google,
Gulf.
like Geo.
Golf Echo,
Gulf.
Oscar. Yeah.
GIO.
Golf Echo Oscar, or I'm sorry, Golf India Oscar.
Yes, sir.
Guido, G?
Geo, yes. Sir.
I-O, G-I-O,
GIO, yes.
Geo.
Geo, yes.
Geography. Okay, I got it. Geo. So here we go again. And I apologize. When is the last time that you had contact with Geo, whether a phone call or ran into him on the street, or when's the last time you actually saw or talked to Geo?
It was through a social media platform. We exchanged a couple of phone calls, and that's it.
And what date would that have been?
I don't have the exact date, but
Well,
it was
you got arrested in October. Would this have been in November or December or January? When would it have been?
a few months after the arrest date.
All right. So you got arrested in October. How many months? 1 month, 2 months, 3 months?
2 months. 2 months.
2 months. So probably December of 2021, the last time you had any contact with Geo.
Yes.
Did you tell your attorney that you had lost contact with him?
Yes.
And how did you know this person?
Mutual friends.
Mutual friend. And like you're in college, you'd see him in a bar or at a beer bust or at a party, something like that.
Just hangouts. Things that I've seen him. We used to go out to eat, things like that.
He wasn't on the football team. He didn't play football with you.
No, sir. No, sir. No, sir.
Okay, I got you. Now, was Geo with you, perhaps drinking beer or something before you were arrested, and that's why he'd be a good witness for you? What is he going to be able to testify to that helps you?
Just conversations that I had with him before I got arrested.
All right, and bear with me, I missed that. Common sense things, is that what you said?
Conversations I had with him.
Conversation. All right. This was a conversation between you and Geo, is that correct?
Yes, sir.
All right. And what did y'all talk about that would help you at a DWI trial?
The things that he knew that would help the jury, things that he would only be able to testify that would help evidence that he would have prior to my arrest. What was going on.
Listen, what can Geo testify about that will help you at your DWI trial? You still have
evidence of conversations that I had with him before I got arrested.
What did y'all talk about in your conversation?
We talked about him possibly needing a ride due to he was out and he reached out to me.
And how does that help you in your DWI trial?
We just had conversations along with that.
Judge, I'm sorry. We got someone else into the Zoom here. Is that
This is Josh, who runs the Veterans Treatment Court.
Oh, okay, Judge. Yeah, because
I apologize. I didn't know if y'all were still in this. We had a staffing at 3, but I will log out and we will.
This is an open hearing. You're welcome to stay.
Yeah, I didn't know if he was a judge. I think there's some confusion as to on Mr. Olguin is not understanding the question that he's being asked.
Can you answer that for me, please, Sophie? Can you tell me what this witness would have testified to that would help your case?
Yes, Judge, the witness was with Mr. Olguin before he got arrested by the police. Mr. Olguin had been with his mother at home, and after that incident, this individual called him. He was out with this individual, so this individual was aware of whether he drank, how much he drank, where they were, and what happened that evening, the facts of the evidence of that evening. When Mr. Olguin was going to take this individual home, but the individual wasn't ready to leave, at that point, he went to pick up food and was going to come back for him, and that's when he got stopped by the cops. So he wasn't there with him at the time, but he had been present with him throughout the evening.
Your Honor, at this time, I'm going to have to object. We have defense counsel testifying for the witness, and she's testifying to facts, starting evidence.
Thank you, John. That's overruled. This is a a hearing. It's not in front of a jury. And I asked Ms. Martinez specifically that question that she answered for me. So thank you.
Thank you, Your Honor.
That being said, what was Gio's testimony going to be on how many drinks of what kind of alcohol that Mr. Olguin had before he drove away and was stopped by the police? Do we know?
I believe that, well, I'm not gonna get into the specifics of that if we're gonna get into a trial at this point, Judge. But he was
Obviously-
aware.
Here's my point. Obviously, if he was going to say that each of them had 10 beers in 2 hours, that's not going to help him in a DWI trial. If he's going to say
No.
that 1 beer an hour for 2 hours, that would help him. But you're the defense counsel, and that's
Well,
not blowing your case, I don't think, out of the water by
No,
asking.
No, Judge, it's just, he was with him throughout the day, so he was aware that he had not consumed that much alcohol. And what he had consumed, he was aware of the times he had consumed it, and he was aware of some other facts that had led to my client on the video was emotional and upset because he had found out that evening from his mother, who had driven down from Dallas, that his father had had an affair. And the mother and his sister came to give him the notice to tell him that day. And they came to school to tell him that. He was upset. He went out, he was with Gio and with everybody else. And that was what happened. In addition to that, you know, he was going to testify about Gio's, about, you know, what he knows from him and the course of the behavior in that night.
Okay, and then Ms. Martinez, would you agree with me? Even if you had gotten a jury trial in December of 2021, 2 months after the arrest, 3 months after the arrest, perhaps, that you still wouldn't have had Mr. Gio to testify?
Well, Judge, I think that's why I think there's some confusion from my conversations with Mr. Olguin. Number one, I believe that the file, there was no jurisdiction for the court until December 21st because the file wasn't ready. I believe that complaint shows that. So, you know, for that month and a half, I believe the blood results came in November 3rd, but the state didn't file the case till December 21st. So even though he was arrested October 6th, the court didn't have jurisdiction until December 21st for us to move on that. Mr. Olguin had indicated to me that because the individual was on campus, that he would be able to have contact with him. But they didn't have interactions every day. So it wasn't my understanding or his that he was not going to be available for us because they were all still at the university. So they could have had communication with each other or found each other. It was only after he left the university in May because school was finished and he was no longer going to have scholarship money that he was unable to locate him or have friends that could locate him. And thus it became more difficult for us to be able to have contact with him.
Well, if the information wasn't filed by the state until December 21, and Mr. Olguin lost contact with his friend Gio about the same time, there was no possible way you could have used him in a trial anyway, I guess, is there?
Well, Judge, we could have, if he was still at university, it would have been easier for him to contact somebody who's on campus with students. But, you know, once they were no longer there, then he didn't have the ability to go look for him because Mr. Olguin lives in Dallas. And the individuals who were there were not able to help him locate him. And that's why we're doing the hearing on Zoom because he is in school there.
Confirm for me that my understanding is your understanding that Mr. Olguin testified that he lost contact with Gio, his witness, sometime in December of 2021. Would that be accurate?
It's my understanding that he wasn't communicating with him on a consistent basis, but that he was able to get a hold of him if we needed him. It was my understanding at what had been communicated to me from Mr. Olguin during the time that we were pending this case, but it was only after he left in May that he didn't know how to reach him. The phone number wasn't any good anymore, and he did not have people who could contact him.
Okay, Mr. Olguin, on January 1, 2022, Did you have a phone number or a means whereby you could have called Gio and talked to him?
I was in contact with him. If I needed to talk to him, I could have contacted him, but I didn't need him there.
You just told me a few minutes ago that you lost total contact with him in December of 2021. So I'm asking you, on January 1, 2022, did you have contact with Gio? Were you able to?
I had not reached out to him at that time, so I don't know. I just know I had stopped talking to him.
It was a long time ago, all that stuff. I got you. All right, now clarify this for me, and I apologize. This is confusing for me, but you had a full ride scholarship at UTSA for football. We all agree that that's true?
Yes, sir.
And then why did they cancel your scholarship? Because you got arrested for DWI, or why?
It's just team policies. And they, if there was no resolution, that's something that I talked with my coaches that I would have to get that figured out, and I never got it figured out.
All right, so you don't know why they canceled your scholarship, but they did cancel your scholarship. Is that
Yes,
correct?
they did cancel my scholarship due to.
Did they still allow you to play football for the team?
No.
And is that because you got arrested, or why?
Yes, sir.
So if you'd had an actual conviction for DWI at any time during that time frame, the same thing would have happened. They would have canceled your scholarship and they wouldn't have let you play football. Would that be correct?
Yes, sir.
All right.
Judge, I believe he testified earlier that the reason that he was not allowed to play was because there was no resolution to the case. It wasn't because he was arrested, and it wasn't because he was not convicted. I believe he testified when I asked him that they had told him that if he had had resolution to the case, they would have allowed him to stay on the roster.
I understand. And that's why my question was, if he had been convicted, if he'd already had a trial and been convicted, that would have been a resolution. What effect that would have had on his scholarship? And he's telling me that that would have canceled his scholarship.
I don't think that's
He had
correct.
to be
Judge.
acquitted for it to help him in his circumstances, is what he's telling me.
I don't think he understood your question, because I don't
I
think that's,
understand that. No. Then what you're saying is, no, I wouldn't have been able to play on the football team. Yes, and from your question, that makes sense.
If you had a conviction for DWI, they would not let you play football.
They would have let me play football if there was a resolution to the case.
Would they have let you stay on your scholarship?
Yes, there was a resolution. Yes.
Okay, then none of this makes any sense to me. Sophie, you're the attorney. Why would they cancel his scholarship if, even if he had a conviction, they would let him stay on his scholarship? I don't understand.
because they told him as long as the case was resolved and he didn't go to jail. But when his case was still pending, they didn't want to hold a scholarship judge for somebody that they didn't know was going to be somebody that they could still count on, because they told him, if you have a resolution, we don't care if you go on probation. That was his indication to me. We don't care if this is resolved, but we need it resolved. And that's what the pro contract told him also. As long as we're resolved and you know that you're free to participate, then we can continue.
Does that make sense to you, Sophie?
It did to, well, I mean, I asked him to speak to his coaches, and that's the information that I got back from them, Judge, that as long as, you know, there's a lot of kids, Judge, in university that have convictions. It's not a matter of, it was a misdemeanor, so they weren't concerned about that. They were concerned about making sure that he was still going to be available for them, not going to jail, not doing anything like that. And so if he was going to be free to participate, they were okay with keeping him on the team.
And you as his attorney didn't talk to any officials at UTSA during this time frame?
No, Judge, because he provided me, he said he had spoken to them. He provided me a letter from his sponsor, a character letter and some other stuff that I did forward to the DA's office. I was attempting through all the emails that I sent to the DA's office to try to get some offers so that we could have resolutions, but I couldn't get anybody to respond to me. I did get the first DA, Rafael Martinez Horta. We had a phone conversation, and he responded to me and then said he passed it on to Brett, and that Brett knew the facts and he would get back to me if I had been able to get an offer. But it was common knowledge that in County Court 2, Judge, we couldn't get a pretrial conference. I mean, we couldn't get a trial date or a plea date without having a pretrial conference date. And we couldn't get a pretrial conference date because Cliff O'Para wouldn't give me one, because he said that our docket was backed up. So finally, I had some cases from earlier in the year of 21, and those didn't get on on County Court 2's docket until February and March of 22. Not because they were COVID related. Those were even pleas we were trying to do, but it took them over 10 months to even give us dates for pleas.
No, I understand, but I'm still, all right. One last question on this and I'll stop beating a dead horse. Your understanding as Mr. Olguin's attorney is this full ride scholarship is a big deal. That's worth a lot of money and everybody would like to have a full ride scholarship to college. And he probably likes playing football, if I were guessing, because he's very good at it. So all that's wonderful. But when they told him he needed a resolution to the case, if he'd gone down and gotten on probation and just pled out, they would have let him keep his scholarship. Is that your understanding, Ms. Martinez?
That was my understanding. And so I had put in my emails that even if we could get this reduced, try to get an obstruction, try to get something for him. I was trying to work a deal for him because I even put that on there. He's on scholarship and I don't want him to lose his scholarship. And that was part of the email that I sent to the DA's office. So it was my understanding and his understanding, because I asked him to go and speak to his coaches and clarify what our parameters were going to be. Was it only a trial and you would not, what happens if you get convicted? What happens if you get on a DWI? What happens if I place you on probation? And those were the parameters we were given.
Right here today, right now, Mr. Olguin is no longer at UTSA. He's now up at a different school. Is that correct?
He's at North Texas because he lost his scholarship and he couldn't afford to stay.
Understand. And then Ms. Martinez, the only motions I see filed in the court's file are motion to dismiss for lack of speedy trial. I've got a motion for speedy trial, but I don't have it timestamped. Was that actually filed also along with the motion to dismiss for lack of speedy trial in County Court 6?
They were filed as two separate motions, yes, on that date. They were filed.
Which is like July 25th, 2022. Does that sound right?
I believe that was, I'll confirm the date, Judge, but it was when the other motion was filed.
I show a motion for speedy trial in my court file, but it's not timestamped, which doesn't make sense either. Stranger things have happened, as we're all aware. All right. Anyway, so those, I don't see a motion for discovery or a motion to suppress or any other pretrial motions or any of those filed at any time by you or by any other defense counsel?
No, Judge, but Barker v. Wingo does not require me to file that. It's even part of the case law in Barker v. Wingo, Judge, that we do not, there is not a requirement there's not a demand requirement in order for us to get a speedy trial, that all of those factors be weighed together, and that as long as those are one of the factors, and that if it indeed is one of the factors that the court weighs in addition to the other factors, Judge. So when we're looking at this length of delay and reason for delay, Mr. Olguin didn't contribute to any of those delays. State has burden to prove that they didn't have any responsibility for that, but even the state taking 2.5 months to file a case, that was part of the delay there. And the backlog, which was common knowledge, administrative, according to Barker v. Wingo, administrative delays should also be weighed. And the County Court 2 administrative delay was not in relation to Mr. Olguin's, any kind of delay there. It has also been, and I believe, Judge, if you don't have, I can, under Barker, it does discuss that there is no demand rule. In other words, we don't waive any right to speedy trial as long as we didn't do any intentional relinquishment or abandon the right to do that. And so it says that Barker rejected the rule that a defendant who fails to demand a speedy trial waives his right. It says that you assert a right to a speedy trial is to consider the case says Barker rejected the rule that a defendant who fails to demand a speedy trial waives his right. Assertion to a right is one of the factors to consider, and the burden is on the prosecution to show that the waiver was voluntarily and knowingly made. So it's not, there's not a demand rule in Barker. In other words, Barker's saying we have to take these 4 elements and waive, and everything, you know, that we look at here in relation to this case, Judge, we're looking at a defendant's right guaranteed by his right to speedy trial, the 6th Amendment, 14th Amendment of the U.S. Constitution, Article 1, Section 10 of the Texas Constitution, and Article 103, Section 3 and 105 of the Texas Code of Criminal Procedure. So, you know, he has a right to that as long as he's not doing anything to intentionally interfere with that. So in following the protocols of the court, every court has a different protocol. County Court 2's protocols were not the way we are in County Court 6 or any other court where we could walk in and say, set my case for trial. The judge in County Court 2 did not allow that. Her protocol was she required a pretrial conference, which we had to obtain a date from Cliff O'Para. And in all of my conversations with Cliff O'Para, he stated to me that the courts was very backed up. And because they were very backed up, they were receiving lists from Amy Castaño in court administration as to all the cases that didn't have settings. And so he was going by the oldest and giving settings to everything. And since we had not been up on that list, he could not give me a pretrial conference date. So I said, what if I want a trial date, or I want a plea date? And according to the judge in County Court 2, you had to go through a very painful process of this pretrial conference where she would ask you everything about a motion and this motion and that motion and be on for 6 hours before she even let you get a plea date. So we couldn't get a plea date and we couldn't get a trial date because she wouldn't even provide us a pretrial conference date. So Judge, everyone knows me. Everyone knows that Sophie Martinez, I'm sorry on the record, can be a pain in the you know what. And I went day after day, about 15 plus times requesting court dates for Mr. Holguin, and I could not get them. I tried circumventing the court by going to the DA's office because I figured if the DA's office could help me get a plea bargain, then I could something we could agree to, I could try to circumvent and getting there to try to convince them to give me some kind of court date. But I didn't get a response there either, Judge. And so all of that coupled together was not a lack for our trying of doing anything I could to try to get him a court date. And in doing that, we were not able to actually get a hearing date till this case was transferred on June 18th. And from June 18th, when it was transferred to County Court 6, I finally was given a court date of July 27th. At that point, I sent an email to Pat requesting that the case be set for trial, and I filed the motions. And that was the first opportunity we had to even have a setting. So it wasn't that we didn't try. It wasn't, you know, mostly it was County Court 2's fault, really, for not allowing anybody to have a setting. But in that time period, my client suffered a lot of loss, Judge. He suffered loss of jobs, loss of finances, loss of income. And you know, okay, he plays football, and not to be disrespectful to my client, but he, you know, he gets confused with the process and he doesn't understand the technology and the stuff. So as much as could have been explained to him by me or the questions by the district attorney's office, he may not be answering everything correctly, but you know, he did, his defense did give prejudice when we could not assess a defense to this witness who would have testified to the facts of what happened that day. In addition to that, having lost this much money and this many opportunities is a big loss that he cannot recuperate anymore. So we can't go back and say, tomorrow we have a trial, and because we have that trial, he's not going to have lost his scholarship or anything. These losses and these things that have happened, you know, Barker v. Wingo discusses that the only remedy to these types of violations to speedy trial, and the case of Strunk v. United States also reaffirms that, and I have those cases if the court wants me to email them. It says is and according to Strunk, the language in there, in light of the policies underlying the right to speedy trial, dismissal must remain, as noted in Barker v. Wingo, the only possible remedy for deprivation of these constitutional rights. And it reaffirms what's stated in Barker. So I'm asking the court to grant this motion to dismiss for lack of due diligence in violation of his speedy trial rights.
Is this case currently set for jury trial in county court at law number 6 on November 14th, 2022?
It is, Your Honor.
Judge.
And I have one last question for Mr. Olguin. Mr. Olguin, you talk about, I guess this is a professional football team in Georgia or in Atlanta or somewhere.
Atlanta, yes.
What's the name of this team?
It's the FCF.
Okay. And at what point were they in negotiations with you trying to get you to come play for them?
In the summer.
I'm sorry?
In the summer.
Summer of 2020.
2022.
Yeah.
Okay, so it's now August 2022. What month did they first start talking to you in this professional football team?
I talked to them previous in the year once or twice, but I really started talking to them more towards the summer because that's when everything happened, because I was in college.
It's still summer, so it's August now. So that would have been like a month ago, maybe, or 2 months ago, something like that.
About a few months, like 3 months ago, yes.
And then for what reason did they not actually hire you or want you to come play for them?
That due to like not being able to get my court date. Is that what they told me was the main reason. And
Did they tell you if you got a conviction for DWI that you couldn't play either?
no, they just needed a resolution, or needed something, at least something to understand to where I was going to be at.
Sophie, have you got any clarification for that with regard to why the professional team didn't let him play?
Yes, Judge, and Mr. Olguin needs to look at his paperwork because he provided me a copy of a contract that was not signed, Judge. And the negotiations were happening in the spring semester. And this was supposed to be beginning playing in March. The negotiations were in spring of 22, and he was supposed to play for 2.5 months, starting March 15th to June 11th. That's what the contract that I have, and I'm happy to introduce it into evidence and send it to the court. It doesn't have his name on it because this was a preliminary contract that they sent him. The name of the league is Fan Controlled Football. And this was it's a contract that he sent me that he had through DocuSign, but once they canceled the DocuSign, he couldn't get the contract that had his name on it, but he was supposed to play for 2.5 months. So they started negotiating this with him, but then when the case didn't resolve and they weren't sure of his status, that was withdrawn. So that was supposed to be for 2.5 months in the summer, which has already passed now. So that was a limited contract for a 2.5 month period.
And you did you
2-month contract? Yes.
go ahead, sir, if you'd like to say something.
Yeah, it was a 2-month contract. So if you're asking, yes, I wouldn't be playing right now. It was just 2 months.
And Ms. Martinez, did you actually talk to anybody on this professional football team or negotiate on your client's behalf on trying to get him a contract with them?
No, Judge, I was not part of that contract. He had a sponsor that was part of his financial when he was receiving his tuition, room and board. He had a sponsor, and this sponsor was the person who was responsible for negotiating these contracts with him. And in discussions with that sponsor, I believe that sponsor, the letter that I sent the district attorney's office as one of the emails, and I believe that sponsor was the one that had negotiated this deal. But when we didn't have that resolved by March, that contract couldn't be, and they couldn't move forward on that contract.
Okay, thanks. Okay, state any questions based on mine?
Oh, one moment, Judge, please.
Sure, take your time.
No, Judge.
Defense, any questions based on mine?
No, Your Honor.
So if this were cleared up, Mr. Olguin is no longer eligible to get a scholarship at UTSA, is that correct?
Not anymore, Judge. At this point, I know he's at North Texas. He's eligible to try to walk on. And they will see what they can do, but I think he's lost for the fall semester. So I think he has to start in the spring.
Yes, ma'am.
What year are you in school, Mr. Olguin? Freshman, sophomore, junior, senior?
I'm a sophomore in the classroom, junior and junior on the field.
Okay. All right, I don't really need final argument, but you're welcome to do so if you wish. State, waive final argument, or you want to argue?
We'll wait. No, the court is well aware of the facts of this case. The state will waive its final argument, Judge.
Defense?
Defense, I believe we've made our argument to the court, Judge. I'm asking the court to grant the motion.
In cause number 671157, State of Texas versus Abraham Olguin, on the defense motion to dismiss for lack of due diligence and violation of right to speedy trial, the court respectfully denies the motion. Anything further from the state of the defense on Mr. Olguin? However, state, you are instructed to find the earliest opportunity you can that you will be ready for trial on this case. And if for whatever reason you can't get ready for trial on this case, then discuss that with Ms. Martinez also.
We will, Judge.
Martinez wants a speedy trial, so that ball's in your court. And then also, if we're on Zoom right now and we can cut Mr. Olguin loose and y'all can discuss a possible resolution at this time if you wish, or at your leisure in the future, whatever y'all want to do.
If defense counsel if Ms. Martinez has a moment, I would be amenable to be placed in a breakout room. I can speak with her about this case. We can get the ball rolling.
That's fine, Judge.
Pat, can we send the DA and Ms. Martinez to a breakout room?
Thank you, Pat. Thank you, Your Honor.
Let's see if Pat's still there.
And thank you, Mr. Olguin.
Yes, Your Honor. Let me just make a breakout room to put them in, and I can put them in there.
There it is. Thank you, Ms. Pat.
All right.
May I be excused, Judge?
Sure.
Thank you,
Sophie,
Your Honor.
can you get
See
in?
you tomorrow.
Yeah, I'll get in right now. And then Mr. Judge, may Mr. Olguin be excused, and then I can reach out to him after I've conferred.
Thank you, Mr. Olguin. You're excused.
I'm going to take a